Hey everybody, it's Derek Christensen here, founder of Legion Law. I'm coming at you today with a video on the three most common assumptions that people make that are wrong about estate planning. But before I get into that, let me remind you guys how to reach out to me. You can email me directly at derek@legionlawpllc.com, or you can find me on my website, legionlawpllc.com. So let's dive right into it. I actually just met with a client, potential client a week ago, and he came in and had a couple of assumptions that were just wrong. And that's okay. There's nothing wrong with that, but people need to learn more about estate planning because these assumptions you would think are pretty straightforward and pretty obvious, but at the end of the day, it's extremely important to understand the nuances of the law and how it can dramatically affect you. Sorry for the camera shaking a little bit. I'm holding my phone up because I'm outside of the office right now. So that's why it's a little bit different right now. So the first assumption is going to be that an estate plan is just a will. Now, that's just simply not true. I mean, a will is a part of an estate plan, but at the end of the day, an estate plan is a series of documents that contain legal, tax, and financial strategies to make sure that you, your loved ones, and your legacy are protected. So those documents can address both pre-death legal issues and post-death legal issues. Actually, they should address those two types of issues. And when I say pre-death issues, I've talked about this in a different video, but essentially pre-death issues are the issues that will pop up before you pass away. So I got hit by a car, I'm in a coma, I'm under surgery, I can't talk because, I have a mental problem or a disease or something. That's incapacity, and a will does not address, most of the time, pre-death issues. So if you have a pre-death issue and you go before a judge with a will, it doesn't make much sense because a will only addresses post-death issues on how to split up your assets. So you can't go to a judge and say, hey, I'm under a coma, I can't make any decisions on my doctor, so I want my wife to make decisions for me, here's my will. That doesn't make any sense. So you need a power of attorney in that circumstance. So that's a little bit behind a will being an estate plan. It's actually part of an estate plan, but not the entire thing. So you need a lot more documents, and usually it can range from 6 to 10 different documents if you have a really solid estate plan with addressing both pre-death and post-death issues. So that leads into assumption number 2, which is that, okay, if a will doesn't fix pre-death issues, at least it fixes all my post-death issues, right? Well, that's also wrong. And the reason why is because a will addresses what are called probate assets. So a will states, hey, all my assets, I want them split up a certain way. This is how you do it. And I'm going to pick a person to specifically split up all those assets. However, some assets that you have are not affected whatsoever by your will or your trust. So in other words, you could write in your will that you want a specific thing to happen to an IRA, and that won't happen. It doesn't matter what you say in a will. What matters is there are beneficiary designations on the IRA, and that is who is going to inherit the IRA after you pass away. So again, there are probate assets and then there are non-probate assets. And a will only affects the probate assets. So that's going to be your house, your car, some bank accounts, cash, furniture, stuff like that. But non-probate assets, the ones that the wills and the trusts don't affect whatsoever, include some types of bank accounts. You can have your IRA, your 401k, your college savings plan, some healthcare plan or saving accounts, stuff like that. So it's extremely important to make sure you work with an attorney, because if I write in my will, the IRA goes to Bob and the beneficiary designation on the IRA actually goes to Mary, then Mary's going to get it no matter what the will says. And that's an important thing to know because, again, people assume that wills dispose of everything after you pass away. You just need a will and you're good to go. But that's just simply not true. The third assumption is that, what is it? I wrote them down and I'm forgetting it. Oh yeah, my spouse. My spouse can have everything and make all decisions for me, both before I die and after I die. And again, that's wrong. You would assume that your spouse gets to make legal decisions on your behalf if you're in a coma, and you would assume that if you passed away during that coma, that you could have your spouse make decisions for you, but that's not true. It just isn't. Unfortunately, no matter how much you love your spouse, you could love her to death, and you've been married to her for 40 years, you guys are two peas in a pod, you understand each other perfectly, But at the end of the day, if you have a bank account with just your name on it, your spouse can't do anything about it. She can't close it. She can't transfer funds out. She can't pay the bills with it. She can't even access your medical records, even though you guys have been married for 40 years. Same thing after you pass away. There's no guarantee that your spouse gets everything. And in Texas, if you don't have a will and you have a spouse and you have kids from another marriage, then a lot of crazy things happen where some of the kids get some of the property, the spouse gets some of the other property. If it's community property versus separate property, it doesn't take into consideration the fact that you guys have been married for so long and that you love each other. It takes in consideration of who's related to whom and who gets what under certain circumstances. And sometimes your spouse doesn't get it. Like, for instance, if you have a second wife that you've been married for 40 years and you had a kid with your first spouse that you had for 1 year, the kid will get 2/3 interest in your real estate, and the wife will get 1/3 interest in the real estate, but only for her lifetime. So the kid can't sell the property, can't get out of the house, can't rent it out without permission from the wife, and the wife only has that interest for just a little bit of time until she passes away. So it's a really weird dynamic. Again, you would assume that your spouse gets to do whatever the heck she needs to make sure that your entire estate's okay, but that's just simply not true. And it depends on what the circumstances are. So if there's anything I can kind of portray here, it's that estate planning is complicated. You want to make sure you do it right, and you want to make sure you do it correctly the first time, because otherwise, if you mess up, it's a permanent decision. You can't really undo it once you pass away. So you want to make sure you do it right the first time, and you got to have somebody in your team to make sure that all is well. So that's where I come in. That's where I do estate planning with clients who have any situation, and I'd be more than happy to help out, especially with you in your circumstances. So again, you can reach out to me at legionlawpllc.com, or you can email me, Derek, DEREK, at legionlawpllc.com as well. So thank you so much. And again, we'll catch you guys on the next video, but this has been 3 assumptions that you will make that are just simply wrong when it comes to estate planning.